Blood Money. Article by Anna von Reitz. Part 6. Additional issues for the International Court of Justice. The military quandary. The military is having trouble discerning who they actually work for. The Pope, the Queen, the Lord Mayor, or us? The answer is surprisingly complex, but it all boils down to they ultimately work for us. The Queen and Lord Mayor have inserted themselves in the middle and taken control by acting as their paymaster in our purported absence, which is why Serco Inc., a British corporation associated with M16 and the Senior Executive Service, SES, has been cutting their checks. Please note that the U.S. territorial government was never granted any authority to do this, and it has been done under pretext of emergency powers that don't exist. Please also notice that with our appearance and coming into session, there is no excuse for continued territorial overreach and assumption of control of any function not specifically delegated to them under their constitutional agreement. We have objected to the Queen and Lord Mayor exercising control over our military payroll, and have also objected to them assuming free access to our credit for purposes never agreed to, while failing to honor their contractual obligations in other regards, such as securing our southern border, which clearly is their responsibility. Of course, there is the issue that without fulfilling their obligations, they are not only in breach of trust, but in breach of commercial service contract. This places the default and the cost of all of this firmly on them, and which also means that they have to meet the military payroll out of their own funds and show themselves as the brutes and bullies behind American aggression and the U.S. military the whole time. Essentially, they have been using our troops and sailors as mercenaries, using our natural resources and land assets to fund their warmongering for profit, and using a presumed custodial interest in our assets to do it. Now we are back and our actual American government is in session, and all of this so-called mischief has been unearthed and documented, much to our displeasure. We doubt very much that the rest of the world will be happy with the prospect of them continuing this same game via the misuse and abuse of the Chinese people as cheap mercenaries. The discovery of their misadministration and criminal activities in this country and on behalf of this country, purportedly, makes their overtures to China to become the world's new policeman for them and their corporations a more apparent, clear, and present danger to all concerned. We are all faced with the prospect of the military here being out of a job, our country being betrayed in front of the rest of the world, including our allies in Russia, and everyone being bullied and beat up by Chinese instead of American troops, all at the behest of the British Crown Corps, the UN Corps, and the Queen. So, if the military, both the old DoD and the territorial contingent, wish to have jobs and purposes in the future, they need to realize who they work for, the American states and people, and they need to come home and talk to their actual employers. And the Queen and the Lord Mayor need to have some of their more nefarious profit-making and coercion mechanisms examined by the rest of the world, just as the other nations examined their perfidy in India and forced them to make correction and function within the public law and the international law which allows the existence and functioning of their corporations. It's more than past time for the Pope, who in the end is responsible for this entire boondoggle, to examine the treaties allowing the inner city of London to exist, and also the incorporation franchise that allows the British Crown Corps and the UN Corps, founded by Vichy French war criminals, to exist. And as for the Pope and both the administration of the municipal government and the former Commonwealth government being administered as a temporary territorial government here and in Australia, in Britain, in Ireland, in Scotland, in Wales, in Canada, in New Zealand, and elsewhere, Please note the following laws pertaining to the parish law, which is synonymous with the district law of the District of Columbia and the institution of their district assemblies, which are being improperly substituted for our state assemblies, and usurping upon our authority and function. Godwin v. Lennon, 1771, VA, Lexis 1, Act of Assembly, 1748, copied from Act of 1705. Jurisdiction of the General Court. Ecclesiastical visitation and deprivation are no parts of the office of an ecclesiastical judge. Bear in mind that districts equal parishes, and that municipal magistrates, that is, ecclesiastical judges operating in municipal districts, have been used to seize upon and confiscate the assets of their American employers, at the same time as former Commonwealth, but now territorial district judges, have done the same thing in United States district courts. The Pope and the Queen Lord Mayor have been abusing the ecclesiastical courts to commit inland piracy against their clueless American employers, and right under the noses of our military the entire time that this has been going on. Penalties of a praemunire, forfeiture of property, for outlawry, resulting in perpetual imprisonment of the person, which results in a bill of attainder. Like the so-called 14th Amendment, which is outlawed with respect to all Americans in this country by Title IV of both the Constitution of the United States and the Constitution of the United States of America, which has been liberally applied to Americans in breach of trust and commercial contract by these same district courts and their officers. Praemunire. Noun. The offense of asserting or maintaining papal jurisdiction in England. Act of Assembly 1661, Act of 1696. The parishioners are indeed the persons ordered to furnish the money, that is, the municipal citizens of the United States and U.S. corporations denoted as citizens under the Diversity of Citizenship Clause. But the erection of the parishes, that is, districts, and the gift of a salary or stipend, or in other words, the foundation and endowment of the church, is the act of the legislature, meaning the foreign state of state legislature in this case. They, the foreign state of state legislature, direct an officer, in this case a hired jurist or agent, as in IRS agent, operating under color of law, to levy 16,000 pounds of tobacco, in this act, on the tithable, that is, taxable, persons of the parish district. As soon as this money is converted and in hand, it becomes the money of the public. See Act of 1711, C2, 1829 edition. Camp v. Lockwood, 1 U.S. 393, Pennsylvania, 1788. Restitution of estates and properties already confiscated as a result of the War of Independence. As to the restitution of estates already confiscated, it is not required by treaty of peace between the United States, that is the company, and Great Britain to be done, even as to real British subjects. HN 3, a treaty, is just as much a law of the land as an act of Congress. So, property confiscated prior to 1783 does not need to be returned to the prior owners, even if those owners were British subjects, because the Treaty of Paris concluded in 1783 between the municipal United States and the British King did not include any such provision as part of the settlement. Crane v. Reeder, 25 Michigan 303, 1872, under Jay's Treaty of 1794. A delinquent subject is an attainted traitor, referring back to the obligation of the British subjects and municipal subjects to pay war reparations. 332 Michigan 237. A bill of attainder is a legislative, also known as a police act, which comes under the authority of Article I courts, which inflict punishment without judicial trial. As you can see by reading the so-called 14th Amendment to the Constitution published by the Scottish Commercial Corporation, usurping upon our good name and identity in 1868, and operating as the United States of America, Incorporated, the municipal citizenry of the United States were subjected to exactly such a foreign bill of attainder. The problem is that the Pope's two incorporated instrumentalities have colluded together to deliberately misidentify Americans as municipal citizens, and have knowingly prosecuted them as such under false legal presumptions in his own parish district courts. Despite the fact that Article 4 of both the Constitution of the United States and the Constitution of the United States of America explicitly forbids this activity on our soil. As more confirmation of this, you will note the Federal Rules of Civil Procedure published by these courts stipulate an appearance of justice, not actual justice, so that this becomes an admission that these courts have knowingly been operating under color of law on our soil in violation of our treaties and our public law and our constitutions, allowing these purveyors of essential government services on our soil. Jackson v. Sands, 1801, HN 6, regarding immediate, meaning instant action, attainders by legislative acts. See also Jackson v. Vatlin, 1807, and Act of Attainder, October 22, 1779, and Act of May 22, 1722, subsection 8, establishing commissioners of forfeitures. Also, Ware v. Hilton, 3 U.S. 199, 1796. H.N. 5, Confiscation Laws of 1777. Two citizens of the Commonwealth of Virginia, wards of the Commonwealth being administered by the British Crown Government, were not indebted to a subject of Great Britain where the eminent domain of Virginia was confined to internal affairs, and the property of the debt was not within the limits of its territory. Territory refers to the territorial government domain. HN 7. Justice is the right to reimburse the expense of an unjust war. See also settlement at the Appomattox Courthouse in 1886. The various rules that allow bills of attainder to be issued by foreign governments against their own foreign citizenry living in this country, or against the citizenry of other foreign service providers living in this country, based on treaties, don't apply to Americans. In fact, Americans are specifically exempt and excluded from and protected from such bills of attainder by Article 4 of both the Constitution of the United States and the Constitution of the United States of America. And nonetheless, the two instrumentalities of the Pope and the Queen Lord Mayor have knowingly colluded against their employers in gross breach of trust, treaty, and service contract to latch onto millions of Americans and purposefully miscategorize them to be subject to such bills of attainder and subject to two kinds of ecclesiastical parish district courts. For the purpose of defrauding them, confiscating their property assets under false legal presumptions, human trafficking them into foreign jurisdictions, and allowing foreign courts to misaddress them to expedite these known international crimes of personage, barratry, inland piracy, press ganging, conspiracy to evade their constitutional obligations, and unlawful conversion of assets. All the above definitions and case citations are important, as well as the two federal constitutions cited, to form a correct picture of the circumstance that the criminals used to take advantage of their employers under color of law and in violation of both the Hague and Geneva Conventions. Simply by establishing unconscionable birth registrations and registrations of other private property while acting under color of law, the criminals responsible could unjustly enrich themselves in the same way that any identity thief does. In this case, by impersonating their victims as foreign citizenry subject to bills of attainder, pretending a subject matter jurisdiction based on this fraud in the victim's assets, then using the purloined assets as collateral for issuance of credit, running up debts in the names of the victims, and then using coercive force to collect the phony debt from the victims in their foreign parish district courts. While these courts and foreign governments have always had the right to establish bills of attainder on their own citizenry and the citizenry of foreign governments under treaties, they are specifically and explicitly forbidden to apply any such legislative measures to Americans. Rather than abide by this simple constitutional mandate, they have deliberately entrapped their employers in adhesion contracts of various kinds while acting under color of law as the government acting under delegated power, and have thus presumed upon their American employers and misaddressed them, shanghaied them into foreign jurisdictions, and subjected them to foreign courts when no such action was ever necessary and cannot be justified. The perpetrators of this vicious scheme will argue that they were faced with an emergency and had to claim and exercise emergency powers because the American state-of-state organizations and the Federal Republic were both inoperable after the Civil War. But the actual states of the Union and their unincorporated Federation of States were not involved in the Civil War and were perfectly intact in 1865. The public here was simply never informed by traitors occupying seats in the territorial U.S. Congress, and the then state assemblies were deliberately misinformed and coerced to create new state-of-state constitutions that allowed British territorial business organizations to slide like cuckoo birds into a nest that never belonged to them, and to assume service contracts and positions of control that were never knowingly and with full disclosure granted to them by the American states and people. They only succeeded in this subterfuge against their employers via the use of constructive fraud, semantic deceits based on similar names, and misapplying their delegated powers of government under color of law. No emergency ever existed, in fact, as the Federation of States is the delegator of all the powers delegated under all federal constitutions, and those powers that were left hanging by the collapse of the Confederation, providing oversight to the American Federal Republic, reverted to the Federation by operation of law. All that needed to happen in 1865 is for the employers, the American states and people, to be fully informed by their employees. We could have all been spared the Spanish-American War, the First World War, the Second World War, and innumerable war-for-profit conflicts including Korea and Vietnam, Iraq I and II, and so much more pillaging, grief, and suffering, if our employees had simply done their duty by us and the principals responsible for the misdirection of those employees had honorably discharged their treaty and contractual obligations to us. So now we come before the nations of the world and the people of the world and the high courts established to deal with such matters, and we ask for the unified and universal action required to restrain rogue corporations and principals operating crime syndicates in our midst. We sue for the peaceable return of all our purloined assets, including the labor bonds that were used to falsely indebt our people and which established both the U.S. debt and, on the flip side, the American national credit. We sue for the peaceable return and release of all foreign titles taken to our land and our land assets by the Queen and the British Crown. We sue for the return of our purloined state offices from the United Nations organization, noting that Jimmy Carter could not give them what was never his to give. We sue for the return of our Title IV flag entrusted to the British territorial United States. We sue for the return of control and non-custodial ownership of our gold and silver, which was removed offshore for safekeeping beginning in the 1870s. We sue for the instant and immediate cessation of all commercial warfare on our shores being promulgated by any corporation chartered by any nation at all, including those chartered for us in abuse of our sovereign powers. We sue for the international recognition which is ours by nature, and for the peaceful resolution of these issues. The International Court of Justice, the Vatican Chancery Court, and the Court of the Lord High Steward are all invoked. If we, the defenders and keepers of all actual law, and the people of the nations of the world, stand together for justice and for peace, there is no office accorded to man or human which can prevail against the will of the living. Let us all choose to act in the only moment that does exist, that moment called now, and let us act in our common defense against charlatans, liars, conmen, bullies, and other species of banal criminals who seek to attain by guile what they cannot wrest by force of arms or moral persuasion.